You.
I'm going to do the housekeeping now.
That's great. Thank you.
Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We are using Zoom with a goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder, this is a video conference. Per Bagley King requirements, all cameras must be kept on during the duration of the meeting. If you're unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of the surroundings behind you. All committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select enable transcript. Thank you.
Thanks so much. Erica, are you doing our roll call or Kimberly?
Yes, I'll,
Thank
I'll
you.
take
Thanks so
both.
much. Thank you.
Thanks. Blakemore,
Here.
Alsoroff,
Here.
Babcock.
Here. My speaker isn't working very well. I'm going to have to get on another device to be able to hear anything.
Oh, thank you. Wong,
Here.
Milrod,
Here.
Morales, absent. Sandville,
Here.
and I'll go through our liaisons. I see Zach Newman from Legal Aid Association of California, Melanie Snyder from the Judicial Council. And I'll just note State Bar staff are in attendance. Thank you.
Thanks so much. Let's take a moment and see if there's any public comment.
No one has their hand raised.
Okay. So we're going to go to the chair's report, and I'm going to do a brief report, but Erica will let us know if I have overlooked something or include that in her staff report. If you were at the last commission meeting, you know that our rules relative to the support center will instead be considered at our August meeting because there was a comment in that needed to be translated and it couldn't be accommodated within that time. So those are still pending, but following the public comment period. So then they'll be advanced after that to the Board of Trustees. And for this committee, as I mentioned at the Trust Fund Commission, we are going to take a hiatus for the remainder of this year. It's 2 meetings. We have finished a lot of work this year already, thanks to really amazing staff who particularly helped us with the support center rules. And that's because Erica, who has been our primary staff, is moving to the grants committee because Chris McConkey left to take another job for family reasons in a different state. And there's other vacancies at the state bar and just not the capacity to staff the rules committee. And I think the bulk of our work for the year has been done. That said, the grants eligibility committee may well need some assistance, particularly with some of the reviews that they're doing. And so if you have an interest in helping grants by being on the committee, helping with the eligibility review committee process, please let Dwan know, and then she'll be in touch with the chairs, Amin and Erica Connolly, and they'll make some decisions about how we can best be used for the remainder of this year. So that is what is pending for us, along with the 2 items that we have to discuss today. But I'm predicting we will be out earlier than 3 p.m. So that's good news. Okay, Erica, and cover anything else I left in addition to what you want to say.
Thanks, Catherine. I think you covered most of it. I just wanted to really emphasize the help it would give us if anybody is available for eligibility review conferences to assist the GES, the Grant Eligibility and Support Committee's workload. We have a number of new applicants this year, as well as existing grantees who we have concerns about eligibility, and so basically we have a full workload as far as that's concerned, and so any availability that you have to assist would be appreciated. And if you are available, I would encourage you to email Dwan to express your interest so that we can make sure to reach out when we need to start scheduling the remainder of those that haven't been scheduled yet. So,
And if you haven't had a chance to do that, I'll just say it's a really good way to understand kind of what work programs do, but also the State Bar's process for doing reviews and raising issues and engaging with programs directly as part of the eligibility and budget review committee. So I've done it. I found it every time interesting and helpful to my just general understanding. So encourage that as well.
Thank you, Catherine. And just wanted to thank all the members of the committee for the work that you have done on the rules this year and the progress that we've made. We wanted to have this meeting to present kind of the final package of rules that we hope to move forward this year, and look forward to picking back up where we left off. But appreciate all your engagement throughout and the feedback that you've provided to help kind of improve the codification process overall.
Okay. Thanks for that, Erica. So we're going to look now at the minutes from our meeting of February 11th. And are there any comments or questions about those minutes? Not seeing any. Is there a motion to approve?
I'll move.
Thank you, Amin.
I'll second.
Thank you, Tony. Okay, let's do a vote on the minutes.
Al-Saraf,
Yes.
Babcock,
Yes.
Ooh.
Wong,
Yes.
Milrod,
Yes.
Morales, absent. Sandville,
Yes.
Blakemore.
Yes.
6 yeses, no nos. The motion passes.
Okay, so that's going to take us to our first item of business, which is regarding administrative and indirect cost. And I think it is Janet that is going to do the primary presentation. So welcome, Janet.
Hello, good afternoon. Let me share my screen. Okay. All right, can folks see my slides?
Yes.
Sure can.
Okay, great, thank you. So good afternoon, commissioners. My name is Janet Wan, and I am Senior Financial Analyst in the Office of Access and Inclusion, and I will be presenting item 4.1, which are proposed amendments to State Bar rules regarding administrative and indirect costs. So today I'll cover the current rule and practice, the proposed changes, and then end with the proposed resolution. So first, as background, State Bar Rule 3.673 allows grantees to spend grant funds on reasonable administrative expenditures and overhead. The general grant provisions also require grantees to allocate funds between program and administrative costs. And examples of administrative costs include salaries and benefits for HR and IT staff, as well as facilities costs. So these are expenses that typically support an entire organization and that can't be easily linked to a specific project or activity. So currently, grantees must submit a budget after they're notified of their tentative IOLTA and EAF award allocations. In their budget, grantees have to allocate funds between program and administrative costs and explain how they arrived at the amounts on each line item of the budget. If more than 25% of their grant award is allocated to administrative costs, grantees have to obtain approval by the commission. So on this slide, table 1 shows that only one grantee has requested an administrative percent greater than 25% for its IOLTA and EAF grants since 2022. All of these were approved by the commission. The highest percent requested and approved by the Commission was 32.01% for this organization's 2026 IELTS grant. As reference, Table 2 shows the number of grantees who initially budgeted and were approved for administrative percentages between 20 to 25% of their grant awards. All remaining grantees budgeted less than 20%. These numbers, however, do not reflect subsequent budget modification requests that may have changed the program versus administrative percentages. So common administrative personnel costs amongst our grantees include executive, finance, development, grants management, HR, and IT staff, while common non-personnel costs include audit, payroll, and banking fees, as well as accounting and IT software. So the proposed rule revision includes several changes. First,
sorry,
it would.
Ken, did you have a comment or? No. I just saw your screen light up. Sorry. Sorry, Janet.
No, that's okay. So first, the proposed rule would replace the word overhead with indirect to mirror terminology that's used in the Code of Federal Regulations, which dictates federal grants management. Second, the proposed revision would allow grantees to budget and spend up to 25% of their grant award on administrative and indirect costs without having to provide a budget narrative. This would treat the 25% threshold like the federal de minimis, in that the de minimis does not require documentation to justify its use and can be used indefinitely. And lastly, the proposed revision clarifies that the Commission, not State Bar staff, have to approve allocations of administrative and indirect costs greater than 25% of the grant award. So the proposed rules revision is intended to not only codify and clarify existing practice, but also to align terminology with other funders and simplify the budgeting process for our grantees. So I'll open it now to questions and present the proposed resolution, which states, should the Legal Services Trust Fund Commission Rules Committee concur, it is resolved that the Legal Services Trust Fund Commission Rules Committee recommends that the Legal Services Trust Fund Commission authorize staff to make available for public comment for a period of 45 days proposed amended rules 3.671 and 3.673 as set forth in Attachment A.
So are there questions, comments about the proposed rule change?
It seems to be uncontroversial. I would move it.
Yeah, I have a question before we do that. I guess I'm trying, so in the budget narrative, that won't be required for almost every grantee but one, I think, right? Because there's only one person. Is there information that we need that would help us during a review process or otherwise that we're no longer going to be getting?
I think because we've seen common narratives for administrative expenses that we don't typically, I think, have questions for any administrative budgets unless that percent is greater than 25. I think at that point, that's when we would request additional information that then gets presented to the Commission for approval.
I think I'm understanding Catherine's question a little differently. So right now, we would ask them the reasoning why. I think operationally, Catherine, if I'm understanding this right, Janet, you can correct me. If we move towards this, then we wouldn't, it would just be an automatic right there up to 25. So you don't get that additional information right there for the reasons that Janet said. A lot of it is usually, we haven't really seen within that framing, like that has caused us concern because it's very kind of reasonable, but that is what we would be losing, like the very specific nature of a particular grant.
If I can just jump in too, I think to Catherine's question though, we don't necessarily use the information that's provided in the administrative budget narrative for anything beyond analysis of the budget at this point. It's not included in any other kind of reporting. And, on the back end, we now ask some narrative questions about the use of grant funds, like in the IELTA the semi-annual report. And so we would probably get some information about the administrative, like broadly administrative expenditures they might be spending the funds on. But it's not to the detriment of any existing kind of reporting or analysis that we conduct as an office.
Ken, did you have Ken and then Jonathan?
Yeah. Go ahead, Jonathan.
Ken, were you going to speak first, or?
Yeah, sure. Sorry, I've got this echo going on.
And now you're muted.
Phone.
Technology.
Sorry about that. Well,
Ken, you might turn off your computer speaker, and then your phone will carry your sound.
okay. How about that? Still no. Yeah, if I turn off my phone, I'm not going to be able to hear you at all. So I apologize for the echo. I'll just be real quick. I recently went through the grant review process with the PDI committee. I was on the review team for the recent partnership grants. I don't remember seeing any important information in the administrative narrative.
Okay, thanks, Jonathan.
Yeah.
I think that was the end of your comment, right, Ken?
Yep.
Before we consider moving forward with this resolution, just a point of clarification for the one grantee that is asking for more than 31% in administrative costs, is that that's an anomaly, right? That's not typical for grantees, correct?
That's correct. So in the past, what they've cited as the reason for their higher administrative costs is they use it to cover their executive director, development, and HR staff. And I think typically the executive director, if they're like an attorney, that might be covered by other sources.
Okay.
So I'll just say that I have a concern, which is if it becomes an automatic, you can do 25%, you don't have to justify it. We will see an increase. Right now, we have a relatively low number of people that have up to 25%, I think. So I don't know whether there's a disincentive by having to actually think about what you're putting down and explaining it, but I think one should pay attention to whether those numbers go up, because I think that will identify like something about what's happening. So I guess that's my concern about like losing information or suggesting that you can now apply for 25% kind of regardless of any explanation about what it is. Dwan.
I was gonna say, I don't actually know if it's like a bad thing if more programs didn't do 25%. From my experience reviewing these, a lot of programs that don't do it don't know how. Like it's easier to kind of not. Yeah, you'd be surprised. A lot of these smaller programs that are not as sophisticated or are not in the know, they tend to put it into salaries more, not into admin. So again, personally, this is just my belief. Again, I don't know if we start to get more, that it's actually a bad thing. If it's just then like kind of equal for everybody.
We might just, I don't know, my
You don't have
admin rate, I
visibility,
think
yeah,
was
yeah.
like 12%, I think, or 13%. There's a big program and we were really well managed. So I don't know that I think 25% on the natural is like a great thing. But
Yeah, that's fair. Yeah.
anyway, Jonathan.
Yeah. Well, I just wanted to share that I don't know that it's a bad thing, because it's important for these organizations to have a level of flexibility, depending on the organization, especially for nonprofits. They're not well endowed in order to recruit and retain the best possible executive directors and attorneys. We want to make sure, or we want to support them in hiring those people. And sometimes those salaries are higher. And writ large across nonprofit organizations, we try to box grantees, at least I have as a grantee, into these small, 80-20, and it's not realistic. When you think about how corporations work, I can't imagine an Apple or a major corporation saying, we're only going to pay you this amount. In order to get the best possible executive directors, attorneys, and people to do this work, even program staff, they need to be paid. So I think I skew towards what Dwan was saying, that maybe it's not a bad thing if they go if they are getting upwards of 25% to help them with that, to do the work that they do on a daily basis. That's just my thoughts.
Yeah, I think that's fair. I just want to observe that this doesn't impact program staff because they would be directly charged for the work to the programs they're working on. This is sort of the indirect cost of HR, IT, finance, some of the executive director's time. So it's kind of supporting, it's taking potentially more of your money and spending it on your admin cost versus spending it on your program costs.
Right.
I think is how I see it.
Interesting.
Anyway. Okay, other comments? Patience, I think you were originally going to make a motion, so do you want to do that?
Soon as I unmute myself, yes. So made.
And the motion is the one that's on the screen, just so everyone's clear.
Correct.
If I can just make one note. I just wanted to underscore the fact that this also will entail revisions to our general grant provisions, but they don't necessarily require public comment. So sometimes we have put out accompanying documents for public comment, like the policy for the real property purchase that you all reviewed last year because it was such a significant revision and it's kind of a standalone document. But we didn't include it in this resolution because it's essentially a necessary change if the rule were to change. So, but if anybody has concerns around that, I just wanted to mention it.
Okay, thanks, Erica.
Yeah.
Okay, so I think Patience has moved the resolution. Is there a second?
I'll second.
Thanks, Jonathan. Do you want, Erica, are you calling for the vote? Are you counting the votes? Thank you.
Alsaroff?
Yes.
Babcock?
Yes.
Wong?
Yes.
Milrod?
Yes.
Morales? Absent. Sandville?
Yes.
Blakemore?
Yes.
6 yeses, no nos, the motion carries.
Okay, let's go to the next item, which is about denial, termination, or other funding actions. And I think Sylvia is presenting on that, maybe.
Everyone, let me share my screen.
Perfect, thank you.
All right, so
See it. We've got it.
great. Okay, thanks so much. Good afternoon, everyone. My name is Sylvia Nam. I'm a lead program analyst in the Office of Access and Inclusion. I'll be presenting on item 4.2, proposed amendments to the State Bar rules regarding denial, termination, and other funding actions. I will be providing an overview of the working group's recommendations regarding Rule 3.691, which governs reconsideration requests related to denials, terminations, as well as other significant funding actions taken by the Commission. The item, as you know, is part of the Rule Committee's ongoing codification work. The proposed amendments are intended to clarify how Rule 3.691 operates in practice, particularly with a focus on threshold eligibility determinations made during the annual IOLTA and Equal Access Fund application process. The working group included Commissioners Patience Milrod and Jonathan Sandville, and I would like to thank them for their participation and feedback throughout this process. So I'll begin with the governing authorities that inform Rule 3.691, then review current practice and some of the practical challenges presented by the current rule. I'll then discuss the considerations evaluated by the working group, summarize the proposed amendments, and conclude with the recommended action before the committee, and open it up for questions and discussion. So I'll start with the statutory framework. Business and Professions Code 6224 authorizes the State Bar to determine that an applicant is not qualified for funding, to deny future funding, or to terminate existing funding due to noncompliance. Importantly, the statute also establishes due process procedures. Denials and terminations do not become final until the applicant or grant recipient has received reasonable notice, as well as an opportunity for a hearing before the State Bar Court if review is sought within 30 days. The statute also draws a distinction between denials and terminations. For terminations of existing funding, funding must continue at the existing level while the matter is pending before the State Bar Court. The statute does not impose a similar requirement for denials of funding. So as staff and the working group reviewed Rule 3.691, one of the key questions was how to maintain these due process protections while also addressing practical issues that arise during the annual allocation and review process. Rule 3.691 serves as that procedural framework for reconsideration requests. Although the rules specifically references denials and terminations, in practice it functions more broadly because other trust fund program rules rely on it, this Rule 3.691, for reveal of significant funding actions. So for example, Rule 3.661 authorizes suspension, termination, and other enforcement actions for noncompliance, while Rule 3.684 authorizes funding reductions, delayed distributions, and other funding-related actions. Rule 3.684 expressly provides that funding reductions that are staff and commission initiated are subject to reconsideration under this rule discussed today, 3.691. So as a result, this rule functions as the principal procedural mechanism or framework for reviewing significant funding determinations across the trust fund program under the oversight of the Commission. Under current practice, when an applicant or grant recipient is determined ineligible for funding, again, under the oversight and approval of the full Commission, staff issues an eligibility termination letter. That letter serves as a notice of denial and explains the reasons for that determination. It also includes in that notice a copy of the rule and information on how to request reconsideration. If reconsideration is requested, the Commission has a few options. It can affirm its decision, modify its decision, or schedule an informal conference. Applicants and grant recipients also retain the ability to seek review before the State Bar Court. So the important point that I'd like to underscore here is that applicants already received notice of the determination, an explanation of the basis for that decision, information regarding reconsideration, as well as information regarding State Bar Court review rules. So historically, reconsideration requests have been rare. In most cases, the Commission has affirmed its original determination in the cases of ineligibility. And I'm thinking back to the 2025 IOLTA and EAF application review cycle. So the issue identified by staff and shared with the working group relates specifically to eligibility determinations made during this annual review for IOLTA and Equal Access Fund applications. So one of the things as commissioners know, is that eligibility review occurs within an incredibly tightly structured process. And that process includes staff review, technical assistance, eligibility review conferences when necessary, review by the Grant Eligibility and Support Committee, and ultimately Commission approval. Once eligibility determinations are made, fiscal staff have only a limited amount of time, usually a few weeks, to run the IOLTA allocation formula and calculated award amounts for what is currently 118 organizations. If an eligibility determination were reopened through the reconsideration after that review and after those calculations have begun, it would require recalculation of allocations and adjustments affecting other applicants whose award amounts depend on final eligibility determinations. And importantly, because the eligibility review process is incredibly extensive and thorough, there are practical and timeliness questions that become salient. So the working group discussed a number of considerations. On one hand, reconsideration serves important due process functions. It promotes transparency and accountability and provides applicants and grant recipients with an opportunity to seek recourse if they seek one. if they so desire one. On the other hand, eligibility determinations differ from other funding actions. They're based on an objective threshold, a set of requirements, and occur again with a compressed annual timeline. And so staff communicated to the working group that the necessity to distinguish between threshold eligibility determinations made during that annual review cycle and other types of funding actions. So the recommendation before this committee does not include eliminating due process protections. Rather, the focus is whether reconsideration at the commission level is necessary for this narrow category determinations when State Bar Court review remains available. Again, especially given the incredible thoroughness of that annual application review process. So with that background and context, the recommendation is to add a new subdivision, B4, under the proposed language, a denial of funding based on determination during the application review, and one that determines that an applicant does not meet threshold eligibility requirements under Rule 3.680 would be final upon issuance and would not be subject to reconsideration by the commission. So the recommendation before this committee is that the proposal is intentionally very narrow. And when I say threshold eligibility determinations under Rule 3.680, examples include the timely and complete submission of a funding application, the submission of a required audited financial statement, as well as meeting the statutory criteria for qualification as a QLSP or as a support center. The proposal before the committee preserves reconsideration rights for funding reductions under Rule 3.684 and for compliance-based enforcement actions under Rule 3.661. It also preserves the applicant's ability to seek review before the State Bar Court within that 30-day timeframe. So in other words, the amendment to the rule removes commission reconsideration only for this very narrow category of eligibility determinations made annually, while preserving both the State Bar Court review option and reconsideration for every other significant funding action. So I wanted to pause here and open it up for questions before I turn to the resolution in case the committee has any questions. And of course, I also invite the working group members to respond.
So are there questions from other members of the committee? I want to make sure I just understand this, so I'll just take a minute and then other people just raise your hand and we can certainly allow time for that too. So you said it's sort of these narrow threshold questions. So during that application process, what would not be a narrow threshold question? So like, is there a line or it's everything that has to do with that? I guess I'm not certain that it's narrow. I think it's sort of everything that happens in the application, unless I'm misunderstanding.
So just to kind of recap some of what I said, when we have our annual IOLTA and EAF application process, there's incredible thorough review. I believe you mentioned that at the top of the call, Catherine. So staff do very intensive review of each applicant.
Yeah.
The GES committee is made aware if there are concerns. If there is an eligibility review conference, that is done with two commissioners, generally comprise a working group, oftentimes with leadership of OANI, as well as OGC.
Yeah.
And then we make a recommendation before a GES, before it goes to the full commission. And so within that incredibly thorough review process, does the organization meet the statutory requirements? Primary purpose, for example, is one that I think comes up quite a bit. Did the organization submit or not an audited financial statement as required by statute as well as our rules? And did they complete the application, for example? Sometimes parts are missing or it's late. Those are the major criterias that I believe commissioners have heard in different iterations. that would be the narrow, that's what I'm characterizing as narrow. So that incredibly, I believe, rigorous, intentional, comprehensive review.
I'm not
Yeah,
speaking, I agree
yeah,
that the review process is thorough. I'm not
yeah.
really asking about that.
Uh,
It sort of caught my attention when you said it's these narrow threshold questions. And my question really was, are there things that the committee's reviewing outside of these narrow threshold questions, which I understand to be, did you complete the application? Is it thorough? Did you turn in your audit? And do you meet primary purpose? Those are the three threshold. Are there other things that you might, as a committee, that the grants committee might discuss? And if you didn't meet that, you would still be eligible for reconsideration? Or is it everything that happens in that process is considered a threshold question? And if GES determines you're not eligible for any reason during that process, then you don't have reconsideration, but you retain your right to the state bar court.
yes, because it gets elevated to GES and then it becomes, there's an eligibility review conference behind closed
Yeah.
doors with commissioners present, with staff present, with OGC present to discuss anything outside of that narrow threshold eligibility, if there are questions that were raised during the application review, if I'm understanding the question. And I saw Erica raise your hand if you also had a response.
Yeah, just to add to that, everything that goes into application review is essentially a requirement in order to be found eligible. And so you are correct, Catherine, that there are a number of inquiries that we make. The ones that Sylvia cited are the most common and often sort of the most concerning or the most considered sort of the top criteria that we're looking for, but there are other aspects of the application that are relevant. For example, it is a statutory requirement that they have approved quality controls by the state bar.
Right.
So quality controls would come into play. We see that less often with, say, a first-time applicant, but they do come into play if there's been ongoing non-compliance concerns. And so it would be part of that. But to what Sylvia was saying, because the process is so deliberate and careful and has these various touch points throughout application review, it was felt that there is a lot of process on the front end to allow the organization to present their best case or provide more information or essentially update staff and the commission before reaching the point of an ultimate determination that would, potentially impact
So
them.
I'm not questioning the process.
Yeah.
I just wanted clarity that it's not really these narrow questions. I think my understanding would be if if there's something required in that application and the staff and as verified by the GES committee determines that you didn't meet that qualification, that would be the basis for determining you're not eligible, whether it was those top three things that Sylvia mentioned, or whether it's the not having the procedures that you mentioned. It's sort of anything within the scope of that application could be the basis for it. And I'm not necessarily disagreeing with like, this isn't a sensible process to do. I just want to make sure we all understand it's sort of anything that happens in that application process, and it happens every year. So during any year in which you didn't meet it, you could be denied. And your option at that point would be for a hearing at the state bar court. And what I understood Sylvia to say is if you request a hearing within that 30 days, your current grant amount would continue, not your new proposed grant amount, but the money that you received last year, which could be higher or lower, I guess, would then continue while you're going through that hearing process, right?
Yes.
Okay.
Yeah.
Patience. Sorry.
And I'm also happy to answer that question of what happens if an applicant is seeking recourse through the state bar court, kind of operationally, if that's like a question of like holding back money and what that means in case the state bar court rules in favor.
Okay, because Patience has had her hand up, so let's hear Patience, whatever Patience has to say, and then since I wasn't aware you could hold back money, then I guess we should, so we're all understand what we're voting on and the change, like it's helpful, I think. So patience.
Thanks. Um, Catherine, thanks for raising the fact that this isn't all objective and quantified. Even some of the quantified criteria like principal purpose. And the example I keep thinking about is UFWF last year. And so the way I came to terms with this, I'm really glad we ended up funding UFWF. That they do really important work, and full disclosure, working with them on a pro bono basis. But that what happened with them was after a significant number of back and forth, and they kind of couldn't get their act together and couldn't figure out this and that and whatever. And it was a good example of the staff bending over backwards to ensure, to help the applicant figure out what the heck they're supposed to be doing. And then, as Duan pointed out at one point during the process, oh my gosh, we reconsider and we grant them, like, all of a sudden now they're eligible, and now we have to rejigger the whole allocation process. So this makes sense to me that we make our peace with the fact that there are going to be, the state bar court appeal remedy is going to have to be the remedy, because it's just too disruptive for staff to have at the last minute commission reconsideration and then have to redo all that other work. And I think it's fair to begin to teach our applicants that, you know what, y'all, you would not file pleadings that were this poorly prepared, hopefully. So, there's a standard that we need to be adhering to. So what if we do that? And I think people will learn to be thorough and complete first time around. So this feels to me like the right balance of rigor and mercy, as it were. So.
Okay, thanks for that. I think Erica and then Ken had a comment.
Thank you. The other thing I just wanted to emphasize is that the decision before the commission is not, when making eligibility determinations, is not just a binary of either eligible or ineligible, that the commission does have at its disposal the ability to impose conditions on an applicant, for example. And so taking the step of denial, I think, would be only in the circumstances where the commission is truly convinced that there is sufficient justification to take that step. And so it's just, I just wanted to remind folks that there is that option. And then I think this is what you meant, Catherine, but I just wanted to clarify that the continued funding for an existing grantee, that is in the case of a termination. They would need to continue receiving their funding at the existing amount. But if they're denied, I don't believe that it would necessarily continue into the next year. Let's say they're appealing that decision.
So maybe then help us understand the difference between termination and denial. So termination is for current grantees and denial is for new people, or did I get that wrong?
Yeah, it depends on the time period you're looking at. So when we're doing application review, it would always be a denial because that's for future funding. When there are compliance concerns, for example, and there are review conferences during an existing grant year, and if the commission feels that there are sufficient circumstances to terminate funding immediately and not necessarily just not renew funding, then under those circumstances, the existing grantee during that grant period would continue to receive their award.
Okay, so I mean, so I think it's important for us to understand that everybody starts at a zero base every year,
Yes.
right? And you are just the same as a new grantee. And if you're denied, because it's not a termination, it's a new grant period, then you will have all these clients you've been serving that you will no longer have the state bar funding to provide for that service. And I think I mean, I think that poses organizational challenges. That doesn't mean we shouldn't do something. But when Sylvia did her presentation, I in my head was making a distinction that if you had been a grantee and receiving funding, that you would continue to get your last year's amount during the state bar appeal process, which is, I think, what would have happened during the reconsideration, maybe, but I don't know for sure. So it's
I
just.
can get clarification on that.
You would
Let's go to Ken. I mean, I'm taking up, it often happens. I tend to have a lot of questions. So go ahead, Ken.
So the existing rule provides for the review by the state bar court, correct?
Yeah. Yes.
So has anyone ever sought review by the state bar court? And has it ever handled one of these matters? I mean, I'm on so there's an equivalent of the Jenny Commission for the State Bar Court, as State Bar staff knows, called the AENC. I'm a member of the AENC and have been for 15 plus years. I don't think this is on any member of the State Bar Court's radar screen that this is part of their job responsibility to review requests for reconsideration or appeals, basically, from determinations of the Trust Fund Commission. So if suddenly this is going to become the court of last resort for an applicant who's denied, we definitely need to let the state bar court know that they may suddenly have a workload in front of them that they're not anticipating.
Well, and I think then the question is, let's say you prevail at the state bar court. So now the commission denied you, you go to the state bar court. You may or may not get funding if you've been a current grantee during that appeal process. It sounds like not. I don't know how long that process takes, but you file your appeal and you win. Then what does that win mean? Do you get your money retroactively? You don't get your money? Like, have we contemplated how that all works?
I can respond to a little bit, but I actually don't remember how it all works. We have figured it all out when we had a couple of compliance issues last year, but I just want to answer the question of Ken narrowly, has this ever gone to state bar court? There was only one instance where it almost went to state bar court. It was my understanding was before my time, it was about probably 15, 18 years ago. And it went and there was, they knew that was coming. And then at like the last minute, got mediated and we paid out the grantee and it never actually made it there. But that was the only time that was close. And the other piece about
there were other options, right, before. So you did this reconsideration,
Yeah,
which
exactly.
people did do. So
Exactly.
presumably people that were going to do reconsiderations are now going to go to the state bar court instead, right?
Yeah, but we have not notified the state bar court or coordinated them. So I think that's a really kind of good point to give somebody over there a heads up if this rule passes. And I just honestly, I cannot remember. And I know Brady and Raul at one point had like walk us through in terms of if they filed a reconsideration, do we continue to pay or not? But I don't know that. And I don't know if Erica knows that, but we can also ping OGC and get that.
I feel like it would be helpful for me at
Yeah.
least to know for current grantees whether there's sort of this, you get your funds while you're appealing, because I recollect that the state board bar court process was long, took a while. And then I don't know what happens if you prevail in that year and what happens to the money that's now been distributed, or do you hold back the money that would have gone to that grantee during that? Like, I just feel like there's those sort of questions for us to understand.
The statute says regarding this, pending final determination of any hearing held with reference to termination of funding, financial assistance shall be continued at its existing level on a month-to-month basis. And earlier in that part of the statute, it references denial and termination, so it's not being used as sort of a combined phrase. So I think it pertains to the termination aspect rather than when they're being denied for future funding. But of course, like I said, we will get confirmation on that, but that's the kind of the short or immediate answer.
So that answers what happens potentially that answers what happens during the period of appeal, but what happens if they prevail then?
Like if they get paid, they would get paid out. They would get paid. They would be made whole if they
But and so that's what I'm asking, just the mechanics. So
Yeah.
like, do you
Yes.
not distribute that money that you would have give this? So they were going to get $1 million, and you're not going to distribute that to other
Oh,
programs?
that I can answer
Yeah.
because I know it mechanically. So what we would do is, if the commission has made a decision, we would run the allocation based on that. If it's a denial, then we would go back and then we'd ask the commission whether we could pull it out of our reserves. But we don't hold back that funding. It feels too like unknown. And then if we then have to later on, it's just a lot of work to redistribute it. So if they come back and they win on appeal, which likely they won't, that's the idea, then we would just pull out of reserves, but we're not holding back the funds.
I think
Okay.
that there's the balance. So to Ken's question, the only time reconsideration requests were made for this initial threshold eligibility was in 2025. It was the only two instances that I found in our records. And there was a potential for an ineligibility determination to go to state bar court in 2019, but OGC advised, and I think that the commission revisited and then its ineligibility to in that question, Catherine, if
Sylvia,
I
you're kind of, yeah, I'm sorry, you were just fading away,
Yeah,
so
you put out a little,
oh,
Sylvia.
we missed kind of the middle part.
oh, okay. Yeah, my internet connection's not that great. So there were two cases, there were two requests for reconsideration that happened in 2025. But I believe in those two instances, one organization did not submit an audit, and I can't remember off the top of my head what the other one was. So the commission
I think
affirmed
that was
its,
both of them.
oh, both. Okay, so affirmed its decision because if an audit is not part of the application, I don't think that the commission actually has discretion, and I can't remember the other rule. And then there was an instance where one organization was determined ineligible in 2019, but the commission went through that reconsideration process, and that organization, and then reversed its decision, and that organization was made whole based on the terminology that Dwan used. And then, Catherine, I don't know if this is part of your question, but I do think that part of what staff and the working group talked about was how do you ensure that the existing pool of grantees remains whole along with that applicant who is seeking appeal to ensure that they may receive their money in case the court rules in their favor. And so Dwan offered an option about holding back the money so that other grantees are not quote unquote denied their fair share in that year, and running the allocation so that that applicant who's seeking appeal is not like penalized in case that decision is reversed. So that applicant can be made whole through money that's set in the reserve and then
Yeah,
given
that's
their
what I heard
yeah
Dwan
yeah
say
yeah.
is that we wouldn't hold the money back. Everybody, so the formula, the amount available that the Trust Fund Commission approves would be distributed based on those found eligible. If you're found ineligible and you appeal, then you would be made whole if you prevail after you but with the money that's in reserve. So there's at least 25 million or whatever that number is that's in reserve. So that
And that organizations don't perceive their numbers dropping if in case it like in terms of the calculation, if it's like a fixed pot of money, the other 117 organizations are given their allocation.
Well, yeah, in some ways they would actually get more because you would reduce the number of people that were eligible. So, I
Yeah,
mean,
that's
it's right. I mean, whoever, as I understand it, whoever is determined not eligible because it's an annual thing. And do we know how long these state bar court proceedings take?
We don't
Is
know.
there a timeline that they have to follow?
I don't know. And Raul is coming, so maybe he will know. He's coming over.
I
I
guess
don't
that's
know
my
that
last
particularly.
question. It's just like, how long does it
Yeah,
take?
I don't know.
Okay, other people have questions?
Hello.
Hi, how are you?
Good. How are you?
Good, thanks for joining. I think we sorted out a lot because Sylvia and Dwan are very knowledgeable. So this rule proposal says don't have reconsideration. I think many of us were at the meeting last year when it became apparent why that wasn't going to work. And your option instead is to, within 30 days, file with the state bar court. But none of us on this call understand what the timelines are for that process. And at least for me, for existing grantees, if they were to lose the state bar funding, for many of them, that is a significant part of their budget, and their ability to serve people is going to be impacted because there's no like equivalent of aid pay pending, which we've also sorted out. So how long does this process take? Do we know?
It's a good question. As far as I know, this is not something that has ever gone to state bar court, so we don't have a good example. And these types of proceedings, I imagine, would be very different than what they usually handle with the discipline related. Um, so I don't have an answer off the top of my head. I can look into this and maybe report back for when this goes to the commission if this comes up. But um, we'd have to look at our state bar court rules of procedure and see if it sheds any light.
Well,
It
I don't know if
doesn't.
this is definitely not like apples to oranges, but like with the disciplinary, can you give us a timeline of how long that takes? Is it like a couple months or a couple years, just
I
even?
don't know. John Eastman took a couple of years, but that might have been an
Right.
outlier.
It could depend on the complexity of the
Okay.
case. It's a lot of factors. I'm not sure if that's a
Okay. Gotcha. Okay. Never
yeah,
mind.
handy reference.
Erica has her hand up.
I unfortunately can't give an answer to the question about the timeline either. But one thing I just wanted to share, I don't know if this helps with the concern, is the framing that, you know, if the commission takes its opportunity for reconsideration, if anything, most of the time, because so much work went into the decision the first time, it's unlikely that it's going to change the outcome, and it will prolong the timeline to get resolution. So nothing about this rule change impacts the existing process, whatever the procedural aspect is with state bar court. And so if anything, it allows them to move on to that process more quickly if they feel that they were wrongly denied their funding. And so I know that doesn't resolve the concern necessarily, but just thought maybe I would frame it that way for consideration.
How long for reconsideration? How long did they have to make a reconsideration?
The first 30 days. And it's the same with the state bar court, even though the rule of proceedings doesn't have any language on the process time, they have to request a hearing before the state bar court within 30 days as well.
The commission has 90 days after, so the applicant has 30 days to request reconsideration under the current rule, and then the commission has 90 days to make a decision. And then they have to deliver their decision within 60 days if they have a conference. So
If they have a what?
if they have an informal conference before making their decision, then they need to send their decision within 60 days. But if they're just going to, you know, reverse or affirm, they have 90 days to do it.
Good job reading the statute.
Yeah, I'm sorry.
Erica's always a wealth of information. Okay, other comments? So the next steps, so this would go to the August commission meeting? Not to the July one.
Correct. Yes.
So is it possible to get some sense of, I guess I'll say two things about this. If we recommend this, I don't think this should be on a consent calendar. I think everybody should really understand what this change is about. And it would be helpful, I think, to understand what the state bar court process is, so we all understand what due process means in that context. So those are my suggestions. Other people have anything else to say?
Oh, one thing that is in the memo, but I didn't introduce during my presentation, is that when we sought feedback from the legal aid community, both through a presentation, there were no comments or questions, and there were no comments or questions facilitated by LAC.
Okay, thanks for that.
Should I read the resolution? Erica, do you want?
I think we all see the
Okay.
resolution on the screen that that we're recommending it to the Legal Services Trust Fund Commission to make it available for public comment of 45 days. And I guess my clarification was, so this is going on in August and then there'll be 45 days, but I'm asking that it not be on the consent calendar. So
We'll
the
put it on
commission,
business.
and that we can have the information about what happens at the state bar court. So just so we're all clear about sort of what does due process mean. But is there a motion based, does anyone want to move the resolution?
I'll make the motion.
Thank you, Amin. Is there a second?
Second.
Thank you, Patience. Do you want to do a roll call vote, Erica?
Sure. Alsaroff,
Yes.
Babcock,
Yes.
Wong,
Yes.
Milrod,
Yes.
Morales, absent, Sandville,
Yes.
Blakemore.
Yes.
6 yeses, no nos, the motion carries.
Look at that. Quickest meeting ever.
Very efficient.
So thanks for all of the staff work. If there are any other comments commission members want to make? For those of that you weren't here, Tony was telling us she's having some medical procedures later on in the fall and she's going to miss the commission for a little bit. So we just wish her all the best and send her good luck for all that's happening. She's such an important part of this committee and the commission as a whole. So we look forward to your healthy return.
Thank you, Catherine.
Okay. All right. With that, I think we can be adjourned.
Thank you.
Thanks, everyone. Thanks. Bye.